Hi, let's talk about business-to-business non-disclosure agreements. I'm Tai Litao, and I'm a lawyer who's been practicing for nearly 15 years. I've had stops in finance, renewable energy, tech, and manufacturing. And in each of those industries, my legal team has been responsible for drafting, reviewing, and approving a wide variety of NDAs for a wide variety of business purposes. In this training, I'll walk you through the essential steps and legal principles for reviewing NDAs in a B2B setting. I've tried to take every best practice and industry standard I've seen and put them together for this training. By the end of the video, you'll know how to identify key clauses, spot red flags, and confidently review NDAs to protect your business's interests. So here's our roadmap for the training. We'll discuss what an NDA is, the different types of NDAs, and then we'll walk through some guiding principles for NDA review, covering each key clause in detail. At the end, we have a checklist that summarizes everything that will be covered, and it can be used as a shorthand tool when you're reviewing an NDA. A non-disclosure agreement, or NDA, is a legal contract that protects confidential information. It prevents unauthorized disclosure or use of sensitive business data. NDAs may also be called confidentiality agreements or proprietary information agreements. Companies use them when exploring new business relationships, working on joint projects, or collaborating on special opportunities. Simply put, NDAs allow businesses to share confidential information safely by minimizing legal risk if the other party wrongfully shares or uses your information. There are three main types of NDAs: one-way NDAs, which may also be called unilateral NDAs, two-way NDAs, which may also be called mutual NDAs, and multi-party NDAs, which often come up as three-way NDAs. Now, one-way NDAs only protect one party's information. For example, when a vendor shares its confidential information with a potential client, only the vendor's information is protected. Here, if the client shared its confidential information with the vendor, the client's information would not be protected. Two-way NDAs protect both parties, and because both parties are protected, it's the most common type of NDA for B2B relationships. Then there are multi-party NDAs, which involve three or more parties, where each party may be a disclosing and receiving party under the NDA. Now, under each of these types, the key part is that the NDA should protect the disclosing party's information from unauthorized disclosure and use. Here's an important reminder: never trust the title of a contract. Whether it's an NDA or any other written agreement, you always need to review the terms. Titles and headings can be deceiving, and the actual terms and conditions can often differ greatly from what the title or heading implies. For NDAs, just because it says mutual NDA or two-way NDA, it doesn't mean it protects each party equally. Be especially cautious of generic titles that just say non-disclosure agreement, as it could be a one-way NDA when you actually needed a two-way NDA. The bottom line is always read the terms carefully to confirm what is protected and what is not protected. Here are some guiding principles to keep in the back of your mind when you're reviewing an NDA. Remember, the overall goal is to determine if the agreement fairly and reasonably protects your company's confidential information. It can be helpful to think about it like a journalist. Who is sharing the information? What is the purpose for sharing the information? Where will the information be shared? Why are we or they sharing the information? When will the information be shared? And how will the information be shared? Now, with that said, for normal B2B relationships, you don't need to analyze each NDA like a billion-dollar deal's riding on it. These principles help balance thorough NDA review with being practical in a busy legal department. Good, not perfect, and focus on the basics. For most normal reasons, companies enter into an NDA, like buying and selling things, working with new customers or vendors. The NDA just has to be good enough. You shouldn't waste time negotiating every little detail. Just make sure it has standard clauses and normal protections. Ask questions. In every legal department I've ever been a part of, there's always some friction between business units that need the NDA and the legal team that needs to understand what the NDA is for. So don't be afraid to ask questions when information is missing or you don't understand something. It's very difficult to review any contract if you don't have proper context. The business unit and the person who sent you the NDA should be expected to provide you with all of the relevant background information. Protect and restrict. It's important to remember the purpose of NDAs: to give your company the ability to receive and share confidential information with legal protection against unauthorized use and disclosure. Nothing more, nothing less. Enable the business. Finally, you also don't want to forget the ultimate purpose of why someone's asked you to review an NDA. It's to enable your company to work with customers, suppliers, vendors, and to explore new business opportunities. For most NDAs, it's okay to be tactical, and it's always important to be reasonable and efficient. Okay, now we'll walk through each key NDA clause and talk about why these are important when you're reviewing an NDA. When you begin to review an NDA, one of the first things you should do is determine its type and make sure it fits the business purpose. If both parties intend to share confidential information, it needs to be a mutual NDA. If you have more than two parties, you need a multi-party NDA. And always be cautious of one-way NDAs. Even if your business team tells you your company won't be sharing any information today, that may not be true a year or two down the road. Next, check to make sure the legal names of the parties are correct. Generally, only parties listed in the NDA are legally protected, and only those parties may enforce the NDA. This includes making sure you have the right affiliate, which is important when your organization is large or when the other party's organization is large. If you're unsure, it's best to talk to the business person who submitted the NDA. Most NDAs should include a defined purpose. The purpose is the reason the parties need the NDA. Under many NDAs, only confidential information that is related to the purpose is protected. Broadly defined purposes are generally preferred and give more flexibility and stronger protection. Narrowly defined purposes can create risk. For example, if information is shared that is unrelated to the stated purpose, then information may not be legally protected under the NDA. Almost all NDAs have a section that defines what confidential information is under the NDA. Ideally, the definition should be broad, covering all trade secrets and non-public information, including written, oral, visual, and digital information. Many definitions also list out different categories, like customer lists, pricing lists, financial data, business information, etc. This is usually okay, but you want to make sure the list is non-exhaustive and includes a term like including but not limited to. You also want to make sure confidential information that is viewed, shared, or accessed during site visits and meetings are also covered. If your company expects to be sharing a significant amount of information, you want to avoid definitions that limit protection to only information marked as confidential or proprietary. It can be very difficult to ensure all disclosures have a legend or marking like that. Protection against unauthorized use and disclosure. Now, this is the heart of the NDA. These protections are the reason why NDAs exist. A good NDA should clearly prohibit using confidential information for any purpose except for the stated purpose. It should also clearly restrict sharing information with any third parties. Additionally, it's a good practice to only allow the receiving party to share information with employees who have a quote-unquote need to know for the stated purpose. Under NDAs, the general rule is that information is protected. However, there are several common and acceptable exceptions to this rule. Now, the following categories of information are normally excluded from protection, even if they would otherwise qualify as confidential information. 1. Information already known to the receiving party. 2. Information that becomes public through no wrongdoing of the receiving party. 3. Information lawfully obtained from a third party. 4. Information independently developed by the receiving party without use of or reference to the disclosing party's confidential information. And 5. Information that is disclosed pursuant to a court or government order. An NDA, like most contracts, should provide a term length, which means how long it's active for. You may also see this referred to as the disclosure period. Some NDAs may also have a separate time period for how long you have to maintain protection. This is often referred to as the confidentiality period. Now, acceptable disclosure periods have terms ranging from 1 to 5 years, and acceptable confidentiality periods include terms ranging from 3 to 5 years. When you think about term length, you also want to think about your right to terminate the NDA early. Now, generally, you want the right to unilaterally terminate the NDA at any time, for any reason or no reason, with notice to the other party. One question that all NDAs should answer is what happens to confidential information when the NDA ends or is terminated. Now, most NDAs state that the receiving party must return or destroy all the confidential information. NDAs will also often require an officer of the receiving party to certify that the information was actually all returned or destroyed. Now, with that said, NDA should also have an archival exception, which allows the receiving party to retain one copy of the information if it's part of the company's normal data backup procedures and the archived data is routinely deleted after a certain time period. Most NDAs should not provide any warranty for any information shared. There should be a clause that says information is provided as is and with no warranties. If a party wants a warranty on the data or information, it usually would appear in a contract that comes after the NDA, such as a purchase and sale agreement, supply agreement, development agreement, or some similar type of contract. An NDA should never transfer ownership or grant rights to the disclosed information. The receiving party should only be able to use the information for the stated purpose, nothing more. Remedies and liability sections cover what happens if a party breaches the NDA. NDA should provide the non-breaching party a streamlined path to injunctive relief. Now, injunctive relief generally means a court order that forces the breaching party to stop wrongfully using or sharing the information. Here, you should see language that says breach of the NDA will cause irreparable harm to the non-breaching party and that monetary damages would not be adequate to compensate for that harm. Also, be cautious of any liquidated damages or limitation of liability provisions. These are unusual for NDAs and can pose significant risk if not carefully reviewed against the information to be shared and the business purpose. You always want to check which state's laws apply and where disputes will be litigated. Now, ideally, you'll be able to negotiate your company's preferred state, which is often the state your HQ or primary office is located. Delaware and New York are commonly accepted neutral jurisdictions. These are the housekeeping clauses, things like zipper clauses, amendments, waiver, assignment, and severability. Most contracts should have these clauses, and NDAs are no exception. While they are not essential to the exchange of confidential information, they are important for reducing ancillary risk and to help guide how the NDA operates. Here's an NDA review checklist. Something like this can be very useful when training employees or when you haven't reviewed an NDA in a while and you want to make sure you cover all the key terms. Thank you for watching this video and completing the training. NDAs often signal the start of a new business relationship or a new project, and they are an important part of data and information risk management. Reviewing them carefully and thoroughly helps your company to share information and grow while also reducing legal risk.